So now I'm going to turn things over to Matt Charity, and Matt teaches in the areas of international law, international human rights, international criminal law, and criminal law. So he's actually an ideal speaker to talk about the cases the court decided last term, which dealt with efforts to litigate human rights violations in U.S. courts. Now, in addition to his academic efforts, I have learned that Matt has been deeply involved in Amherst town government, where he served as chair of the town's Human Rights Commission for a number of years. And I don't know if he has aspirations for higher political office, but if he does, I just wanted Matt to know that I'll volunteer to work on any campaign where you're running for office. So Matt, the floor is yours.
I have just about 10 minutes to talk about two cases that came before the Supreme Court during the last term. And the major takeaways from these cases are whether the court is going to recognize that there are political decisions that are made by the executive branch and by Congress that would preclude the court from hearing new rights or recognizing rights that may exist under international law. Both of these cases are about the application of international law standards in some way. So the first case I'm going to talk about is the Federal Republic of Germany versus Philipp, which is a case that deals with genocide. However, the case is not treated as a genocide case. It is a Foreign Sovereign Immunities Act case. And so one of the things for us to take away from this is that the court is going to limit its analysis of the law that applies to the law that it frankly is comfortable applying. I would argue that the reasoning stated by Justice Thomas in the Alien Tort Statute case and Justice Roberts in the Foreign Sovereign Immunities Act case both show a discomfort with trying to apply international standards and even perhaps a lack of awareness of the processes by which we adopt international standards into our national law. So again, I'm going to start off with Federal Republic of Germany versus Philipp. This is a case that focuses on the expropriation exception to the Foreign Sovereign Immunities Act, where we look at a public act taken by a government that typically would not fall under the laws of, wouldn't fall under our jurisdiction. We recognize that foreign sovereigns have a right under international law not to be hauled before the courts of the United States. However, this was a case that goes back to a consortium of art buyers in October of 1929, and that date is going to be important in a minute, who buy what is called the Gelf treasure or the Weltenschatz. It's a set of reliquaries. It's 82 items that start being collected in 1631 that are part of the kind of Christian history in what is Prussia. So they buy this for a certain amount of money and end up selling it for about half of the value of what they purchased it for. And in order for our court to figure out whether that was the German government, which buys it back in 1935, that has become a Nazi government and is therefore expropriating property from nationals of Germany who are Jewish, we need to look at what law applies and what standards should have been applied both in Germany and by our courts. So the underlying processes that have come up through our courts were that the district court in DC and the DC Circuit Court both said that if Germany sees these assets as part of committing genocide, then the case could not be thrown out under the Foreign Sovereign Immunities Act. Now, the time periods that we have to look at for how the law would apply are prior to World War II, the Weimar Republic, when the assets are purchased, in 1935, when the assets are sold, or post-1945, when genocide is recognized as criminal internationally, 1976, when the Foreign Sovereign Immunities Act is adopted by Congress, 1986, when the Genocide Convention becomes effective in the United States, or the 1990s, when international criminal tribunals begin to realize that you're not protected by the country of your nationality if they are attacking your group as such, based on religion, race, or ethnicity. And the argument that's being made by the descendants now of the people who purchased these artworks and then sold them back to the Prussian government at a discounted rate is that they were forced to do so under the National Socialist regime for fear that they would otherwise be harmed, and that this therefore was a seizure, that in an expropriation of the assets of someone who is not really considered a national of the country any longer. So that's the argument that's being posed today. Justice Roberts looks at this from the time frame of when the Foreign Sovereign Immunities Act was passed in 1976, and says Congress was aware at the time that there could be conflicts with other laws, but that we recognize the rights of foreign sovereigns not to be brought before our courts, except under very limited circumstances. And if Congress wants to prevent this type of claim from being brought, and he gives examples of other claims that were brought that had a human rights nexus that were not allowed into the court because of the Foreign Sovereign Immunities Act, then Congress would have, Congress has the right to say what can be brought before the courts and what cannot, and that Congress has not specifically recognized this type of case as one that can be brought before the courts. He skirts issues of comity. So Germany has made some decisions with regard to the assets that they were purchased at a fair market value, especially given the fact that this was during a great worldwide depression and the assets values had depreciated considerably at that time. So, so Germany is trying to make that argument. The descendants are trying to make the argument that the assets were stolen as part of genocide against the Jewish population of Germany. The Supreme Court skirts both of those issues by focusing on congressional intent under the Foreign Sovereign Immunities Act of 1976. And that's a unanimous decision. And I'll just say really quickly that part of the concern is that sometimes bad facts make bad law. So both parties, Germany and the descendants, agreed to go before a panel that would consider in Germany whether the assets were sold at a fair market value. And there was a determination there that the assets were sold in 1935 at the then fair market value for those items. I'm happy to talk more about this if we have some time in a discussion Q&A. I've only left myself a couple of minutes to talk about slavery. So we have a case that comes under the Alien Tort Statute Act, where we have 6 people who are taken from Mali as children to Cote d'Ivoire to work on cocoa farms. And they are therefore engaged in forced labor. Children cannot agree to go to another country in order to engage in labor. There they are tasked with clearing forests so that farmers can grow cocoa, spraying pesticides, all kinds of things that would endanger children. The claim made is that the Cargill and Nestle, 2 companies that were making operating decisions in the United States, were managing farms in Cote d'Ivoire while they, and those farmers were using slave labor. That when Cargill and Nestle sent employees over to Cote d'Ivoire to train the farmers in how to use equipment that were provided by Nestle and Cargill, and that Nestle and Cargill have every right to take all of the crops that are grown for themselves, that basically they owned the property, they owned the farms that were in Cote d'Ivoire, and they were making operational decisions here in the United States, and they saw slavery ongoing, and they decided to allow for the slavery to continue. And that would violate the Alien Tort Statute, because slavery is certainly something that we should recognize as in violation of international law. The Supreme Court, which of course could look at the Alien Tort Statute as limiting the rights under international law to engage in slavery, decides that it's going to look at the three torts that were recognized in 1789. So we're going to look at treatment of diplomats. We're going to look at the protections given by a foreign government for their nationals coming into your country, and we're going to look at piracy. Justice Thomas in particular says those are the only laws that exist under international law that we can apply without Congress making a different determination. And Justice Gorsuch agrees with him on that topic. Justice Alito says we don't need to get there on those issues. We just needed to determine whether a corporation has the same responsibilities as any other individual not to engage in a tort that would be subject to the Alien Tort Statute of 1789. And that's the only dissent. But while Justice Sotomayor does agree with the finding that our own companies could not be held responsible for actions that are taking place in another country, she also points out that it is the job of our courts to interpret international standards of what those torts may be, what international crimes may be over time. And so there's an ongoing obligation for the courts to do that, which is something that neither Justice Thomas, or Justice Gorsuch seem to agree with. So I'll also point out that the Small Business Administration in 2019 against Cargill had found that if you control a farm and you control its operations and you provide all of the machinery and you provide all the training and you have rights to all of the assets from it for the purposes of the Small Business Administration, that is no longer a contractor. That is not a separate entity. That is a subsidiary under the laws of the United States. So one of the things that we need to look at is how we are treating other countries differently, and whether we are doing so because, as Justice Thomas has pointed out, Congress intended for our businesses to be able to work with cocoa farmers in Cote d'Ivoire. And the intent there was to allow for greater business ties and for an investment in Ivory Coast in a way that we hadn't historically done that. And that's a political decision. The problem is, of course, that that's a political decision that we are suggesting allows for US companies to promote slavery in other countries if our Congress has determined that there is an interest in our doing so. Obviously, that should be viewed as against international law and against anything that we should stand for as the United States. I'll end there. I hope that there's time to discuss it in greater detail when we have a few minutes at the end of all the presentations today.